Welcome to Talking Tech with Legal IT Insider. I'm Caroline Hill, and today we are going to be talking with Jylo, founder and CEO Shawn Curran, about a topic which I have to say I'm really excited about because it's not a conversation I would probably have with pretty much anybody else on a webinar. So, as we know, the legal tech market is shifting faster than anyone can probably keep up with, is the truth. Behind all the noise, the integrations, valuations, AI announcements, lies a complex story where law firms need to really be awake as to what the future looks like. It's a very competitive landscape, as you all know, from everybody listening in can relate. Should you build your own software? Should you trust legal AI companies? Do you risk giving away your IP? Is there anything you can do about that, given the state of play in the AI market? I'd like to welcome Shawn. Many of you will know him. Shawn, as I said, he's CEO and co-founder of Jylo. Hi, Shawn. Nice to have you here.
Hi, Caroline. Good to see you.
So Jylo is a platform you may be familiar. It enables law firms to use multiple frontier AI models to create AI playbooks for the likes of document review, drafting, and analysis. Shawn launched Jylo after a fairly glittering technology career at law firms, including Travis Smith, Freshfields, Latham and Watkins. I knew you'd like that word.
Yeah.
He's one of the most technical people I know. That is absolutely dead on. I think so. With some people having this kind of conversation, you might feel the risk of being perceived as being, if you sort of have this sort of conversation, you might feel like you're being a laggard or that you're not just adapting to the time. So I think it's a really timely, at times provocative conversation about what you're seeing in the market. Before I dive in, I'm going to ask Shawn to tell us a little bit more about you and Jylo, just real quick before we dive in, but just so people listening in know what we can expect from the conversation. So we're going to be talking about IP and whether you should be sharing your IP with frontier AI models. We're going to be talking about what people could do differently, given this huge need to compete, whether you should be buying your own AI tools, whether there should be what the balance looks like between law firms and in-house teams, who's best to win, perhaps. In this new era, we're going to be looking at some of the recent announcements, for example, Anthropic, and how that affects that balance. And yeah, looking at a bit of the supply chain in general, where everything's gone. I think it's safe to say it's gone completely skew. Tell us a bit. I introduced you, Shawn, but just for people not familiar, just tell us a bit more about you and Jylo.
Yeah, sure. Hi, everybody. So yeah, my background is that I've worked in private practice as a technologist for most of my career. I started my career working for a law firm in Scotland called McGregor's as a sort of junior engineer, and worked my way up from there. Spent some time at Pinsent Masons when they acquired McGregor's. Then I went to Latham Watkins. I was at Latham Watkins working in the London office as a sort of global engineer for about 4.5 years. And then after that was at Freshfields as a technology architect. So sort of it's a weird word. I think architect, people always get confused with it when we talk about it in the context of technology and not buildings. But basically you're kind of off the tools, not doing delivery and actually more strategy and design. So that was the kind of first step up into management at Freshfields. Worked there for a couple of years. And then after that joined Travis Smith as the head of legal tech. I sort of worked alongside somebody called Dave Cassidy at Travis Smith and Ollie Bethel, sort of technology leadership, building a sort of legal tech function, sort of 4 teams, did that for about 4 years, then was promoted to director. And then just around the time that sort of AI was coming off, starting, we had built a couple of sort of traditional entity extraction tools. At Travis Smith, we actually won a Codex award for one of them, something called Etatona, which was sort of data labeling. We sort of did quite a lot of that sort of traditional finding the change of control clause that everyone else was doing. And then we started getting access to these advanced LLMs and realized that computers seem to be able to reason, and the power of that, I was convinced from day one that was going to be revolutionary and transformative for our industry. Text in, text out, that's what lawyers do, that's what everyone says. So worked quite closely with Ollie and and the board at Travis Smith to see whether there's an opportunity for us to potentially create an independent company and leave Travis Smith, but Travis effectively becoming like venture investors and creating a fund to kind of invest as our initial investors. Loads of other law firms have been doing that. Some are quite open about it, some not. But we were quite open about it. We thought it was a really positive move. And that was about 2 years ago when we effectively spun out as a business from Travers. And yeah, since then we've just been building this sort of modern legal GenAI platform, sort of word add-in as you would expect, sort of volume-based analysis, and then a sort of agentic assistant, all kind of wrapped up in a sort of matter-centric capability and platform.
So thanks for that. I think we first met at that hackathon, or that was one of the first times when you did the Editona. I think I was judged. I don't know how I ended up judging that hackathon. That was a lot of years ago, wasn't it? So tell me about when we first started talking about this, it was around the IP, wasn't it? So it was, your concerns around law firms effectively giving away their IP to frontier AI models, and what that really means. So tell me a bit more about your thoughts at a high level, and then we'll dive into a bit more.
Yeah, I mean, I think we very much, our product is very similar to everyone else doing this. But I think the way that we're trying to differentiate is that we are the AI that you can trust, such that it has never been part of our business model to capture any of the data that is put into our system, to potentially then compete with our customers and go after the person that's buying their service. The line between tech and service is getting ever more blurred. And if in-house teams could just go direct to Jylo instead of going to private practice, then if we were taking the data, there might be an opportunity for us to be able to do that. And so we think that any white-collar service industry should be thinking about buying a tech platform where they can build a kind of layer of competitive advantage and IP on top of these frontier models and make really sure that that data doesn't end up finding its way down to the frontier models. Now, having said that, the release of Anthropic and Claude over there certainly. So you've got somebody joining. Don't know why that's come up.
Scotty's on the case. Scotty's
oh,
on
God.
the case.
That's the first person joining the call. Yeah, I mean, I think if you look at Anthropic and Claude in Opus 4.6, I think that is a real watershed moment for our industry because you can now see that, in my view, Claude Opus 4.6 has got the entire internet in it and has been trained on the entire internet, and now is starting to get trained on professional services, white-collar data that they are either getting through their consumer app or through their enterprise app, where they've got certain terms where they can get access to that data. And I think it's really obvious for us that we've got a word add in now, and if we ask GPT 4.0 to draft a share purchase agreement, it's about 3 or 4 pages. If you ask Claude Opus 4.6, it is the most detailed, sophisticated share purchase agreement that you would expect to see, something that you might get from one of the large publishers or a leading law firm. And I think that it's obvious what's happened there. Those types of documents have been added to that platform. Those vendors have had a license to that data. That has been fed into the model such that it can regurgitate that type of capability or that type of document. And that has now been fed back up to the market. Now, the risk here is that we all go, this is fantastic, and we continue to feed the machine. My view is that the disruption from that will be so significant that any professional services industry will take a step back from continuing to make sure that these models improve, and will be thinking about how they add some context engineering or data engineering layer on top of the foundation models, ensuring that none of that data goes back. So you've got AWS and Azure. They host leading frontier models. They have no incentive to take the data. But you also have the frontier models that sit underneath that. And if you're integrating directly with those, then potentially, depending on the license terms, which, it's up to any company to do any license terms they want, that data might be feeding the model, and it might be further eroding the value proposition of all professional services work. Right? This isn't just happening in legal, it's happening across every single white-collar industry. But that starts to erode the value proposition. And I think when we kind of get done with buying the flashy toy, I think firms are really going to have to think about investing in that IP layer, that competitive advantage layer, on top of these frontier models, and offer that back to clients.
Do you think it's, I mean, by all means, feed in from the chat. I know that it's quite a sensitive topic, but do you think it's unwitting? Do you think it's, I mean, we've heard over the last while, I've written about, people not checking their terms. Obviously, these tools are quite addictive. They are very good already sometimes. And it's interesting because I hosted a panel. There's a lot going on sometimes at firms that people don't even know is happening, is the honest truth. Like I've heard about people using tools for things that they really shouldn't be using them for, and that's come out in a live environment. Do you think it's unwitting? Do you think firms are just not being cautious, or what do you think is contributing to it before we talk about whether the
I
tools
think certainly our customers are diligencing it with us, which is fantastic. We don't have any interest in customer data. It's not even our starting position. It's not like it has to be negotiated away. We just have no business model around taking customer data. We're increasingly seeing customers asking us to deploy Jylo into their private cloud so that there's no technical access. We're really diligent on making sure that all models are first party with the hyperscalers and it doesn't go back to the model vendors. But there is a huge market out there of solo practitioners, of smaller firms who might just want to buy the consumer tool, of potentially in-house teams who are using the consumer tools and maybe their company isn't aware of it, and enterprise data is kind of getting leaked out into these models. And that's something for the company and the organization to figure out. But I think that's still happening everywhere. And so I think we've just realized that a lot of that data has found its way to the frontier labs. And they are now using that data to train the model, and therefore it's now climbing the value chain in the enterprise.
Yeah, I mean, it doesn't surprise me in a way, because we're hearing that shadow IT is such a huge problem that people are, that even if law firms prohibit it, unfortunately, so a lot of people are using it, and then they're probably thinking about it from a privacy policy perspective, rather than from it's not often that I have a lot of conversations around policies and shadow IT and around why that's a bad idea in terms of privacy and client confidentiality and all of that, and privacy and everything. But it's not often that they go, I'm training the model. In fact, I'd say it's almost never.
Yeah, and I don't think for the last 2 years, I don't think we've seen it. It didn't show up. I think it was, oh yeah, people used to say to me, oh yeah, Shawn, that's not really happening, and we'll worry about that. We'll cross that bridge when we come to it. We'll worry about that when it happens. Go and use Opus 4.6 and also now GPT 5.4, which is just coming out, and they're saying it's for professional use cases and enterprise use cases. We're starting to see that enterprise data show up in the model, and it's pretty scary for people because the models are now really, really good. I think there was a stat that says the internet is, I might get this wrong, but like 1 terabyte, and Goldman Sachs has got 150 terabytes of data, private data versus the public internet data. They're going to make sure they protect that. I'm sure they are, but there'll be a whole bunch of smaller banks and finance houses, and there'll be a whole bunch of smaller law firms and so on, where it's kind of leaking its way out. I think we talked about this yesterday, like everybody needs to hold the line, but not everyone's going to be incentivized to hold the line. So it's just going to be fascinating to see what happens over the next decade as these frontier models continue to eat the tasks about, we might get squeezed, being really honest. I could see private practice getting squeezed. I think I talked about this yesterday. I see in-house getting squeezed. I'm a CEO. I've got external counsel. If I could just get Claude Agent to do the entire master services agreement negotiation rather than sending it externally, I might be quite interested to do that, certainly if the price was a lot cheaper. So you kind of see that happening. And it's like the boiling frog analogy. Like we're in kind of lukewarm water and it's getting a bit hotter. We're going, oh, this is quite nice, but at some point we could be boiled to death. And I just don't know where it ends. So I think that we might be at a point in time where the entire internet and quite a good slug of enterprise data is in a model. And then we'll all wake up and realize that we have to kind of stop that. And then these organizations will start to take the models on premise, do deals with vendors where there's absolutely no incentive to take customer data. And then they'll be looking to hire teams, build teams to build that context engineering layer on top. And I think enough organizations will do that. That's certainly our go-to-market and where we're positioning ourselves. And helping those white-collar incumbents sort of transform and become competitive in the future.
That's fascinating. Like, I want to come back to that because that's like putting the toothpaste. Is the toothpaste out of the tube? Can we put it back in the tube? But there's a question in the chat, and I want to encourage people to ask questions. It's actually in the Q&A, so maybe we could just make sure that people can post in the chat. But people have already, so I'm sure that we can. as foundational models as foundational model providers move towards the professional services sectors, presumably higher sector experts, how long until they can deliver the foundational models to us directly with necessary protections? If legal texts can do it, why wouldn't they? I don't know if that's something that you want to address here or after. Sort of a.
I think is the question, why would for example, law firm not just buy direct from the Frontier model rather than coming through a Jylo?
Yeah, I'm not 100% sure, but yeah.
Yeah, if that's the context of the question, I think that absolutely is a risk for our business, and it's a risk for every other wrapper across every other industry. I think, again, I go back to the point of incentivization. Like the frontier labs really want data to improve the model, and it's getting so competitive that there would be a trust point there. But again, it might just get to a point where the price is so reasonable, and the person who wants the work doesn't necessarily care about giving that work to people and is happy to just get it done from an agent or an AI, that the economic model might totally shift. It's certainly something that I wouldn't say worried about, but certainly like in any business, we're tracking it closely and trying to sort of figure out how this all plays out over the next 5 or 10 years.
Do you think you talked about the hold the line? I feel like this is I mean, maybe it's almost unhealthy. You know, competition. We're a market-driven globe. You know, we're a market-driven economy, and innovation is always ahead of regulation. This is something that has always been the case. No matter this is a major revolution, but we've every single step of the way. You know, regulation has been behind innovation, but one of the things, obviously, competition really drives behavior. And you mentioned the hold the line. Obviously, this is something that we had a bit of a laugh about, this idea of this gladiator. I love the movie.
Yeah, Gladiator.
Yeah, I watched it the other day, but you know, this is something that I think people need to think about, right? Like everybody's trying to compete, and we'll come on to in-house teams. So, including, I feel like there's more competition now between law firms and in-house teams, which is there's a new interesting dynamic there. And actually, I'm not sure we're driving the right behaviours given the seismic changes that are coming up. But I also wonder whether it's even remotely practical or realistic to think that people would do anything other than compete and think of their own best wishes, best interests.
Yeah, I think if people don't hold the line, ultimately we end up in a very, very monopolistic future. And not to be too dystopian about it, but we end up in I've got a picture on my phone that came up today. I don't think people can see it, but it's like a young family with no food to eat because like they've not got, I don't know if they see it there, but I do think we end up in a really kind of dystopian monopolistic future where you've got 2 or 3 big companies that have managed to find a way to pull the wool over every white collar worker's eyes and get them to train some foundation model such that they can put themselves in a position of power that then allows them to control and dominate in a way that we'll have never seen before. And obviously that's why 47% of venture capital dollars last year went to OpenAI and Anthropic, right? I mean, that's the bet that people are making. These companies could be unbelievably massive if they're able to continue what they're doing and get access to that. Basically, they would be eating the entire white collar market internationally. I'm not sure whether that will happen. Maybe it's anti-competitive. Maybe they'll get stopped. Everybody always talks about Google being too big, as they are. But I do think it's, I think longer term, AI will end up proliferating, and there'll be sort of lots of smaller tech companies rather than us centralizing and consolidating all of that into 2 or 3 leading frontier lab model providers. But you know, who knows how it all plays out.
What do you make of so there are sort of law firms? One thing, neither of us are saying that law firms are stupid. You know, we've both worked in the legal sector for years, and it's very adaptable, very smart people. One of the things that they're doing, you've already talked about doing stuff on prem. They're obviously working with you, doing various bits. It's not that they're not alive to the risk, but obviously there's that competitive forces. But one of the things they're doing that's quite interesting is building their own tech, which I think is a trend that it's not brand new. Everyone listening in has been in this industry probably long enough that we've seen this at multiple times. But what do you make of that? So like there's firms that are trying to build their own, they're trying to retain their own IP, they're trying to gain competitive advantage by building their own software. What do you make of it?
Yeah, I mean, I don't think you get any competitive advantage building your own software unless you're worried about the software provider taking your customer data and you want to protect that, then yes, but not from the software itself if you've got a vendor you can trust. I think the cost of software delivery and development is coming down so much that it might be enticing for a firm to potentially build if the buy option is excessive in terms of its price. And I think we are seeing some of that in the market just now. So I always focus on this point around the price per seat. It's that you've got to get a price that sort of makes people think they shouldn't be building internally, but not so expensive that there's even a conversation at the board about whether you would or wouldn't do that. And so you kind of just, I think, just take the software from a vendor, put it into your private cloud, or host it if you trust them. And then the key is to build IP on top around, in law, legal engineering, context engineering, something that the model cannot do out the box, like the specific way that your client wants a real estate lease report review to be done that's different to anything that Anthropic could ever do out the box because they don't know that client. Adding that sort of stuff on top. And I think if you've got a certain amount of capital as a law firm to deploy, you'd be much better at deploying it to the context engineering and legal engineering layer than the software engineering layer. Having said all of that, I could be biased because I am selling a software product. And I think if you'd asked me that, maybe some people on the call would be thinking this. If you'd asked me that when I was in House of Travers, I'd be like, build. So I think it's important to be transparent. But genuinely now, I don't think if I trusted the vendor, even as a buyer, as I was for 20 years, and I could do it with a way where they weren't incentivized to take customer data in any way, shape, or form, I probably wouldn't be allocating the capital the board had given me at a law firm to the software engineering layer. I would be thinking more about more about how I would allocate it at the lawyer layer, at the legal engineering layer.
Yeah, it's fascinating because I have a lot of these conversations now more than before. And I feel like one of the risks that of the build is that you've got people who are highly invested in it. They know what they're doing, but they don't necessarily factor in the time as well. The time of people's time is usually valuable. So you've got the time that it takes, the expertise that you need to build it, and then the upkeep, the maintenance side, which can be a real challenge. We know this from past history. It's not too different from anything before where people have built their own and then with the models moving and developing so quickly, it's then that how do you what's the upkeep going to be like? Do you have the expertise internally? I can see I seem like I'm pretty biased, against it. I don't really have any reason to be, but I do feel like there's a risk that you might end up with some kind of like Frankenstein's tech stack internally. That's the risk.
Yeah, absolutely. I think like now people are prompting to build a CRM and a CRM is being built and they're going, oh my God, that's amazing. 3 years ago, you could have gone on to GitHub and cloned an open source repo of a CRM system. Like, that would have been cheaper than paying for the tokens to reproduce those tokens that had been trained, that the model had scraped to then reproduce the CRM system. So it's more just about people are feeling empowered to be able to create software, certainly with vibe coding. And they just, because they never knew that how to clone a GitHub repo and how to deploy that in the past. So I think it's a trend, it's a period. I think it will come and go. I think you're right. Firms will end up with a lot of these little Frankenstein's monsters on the vibe coding side, and they'll then look to consolidate into a platform. But having said that, one of the things we're super interested in is whether we can let people vibe code certain like user journey workflows in Jylo that sort of support their process that's very unique with all the sort of ISO and SOC 2 and everything we've got, but doing it safely and securely, where we'll do a sort of security test before it's published and all that sort of stuff. I think that's a trend you'll start to see for some of these platform plays like us, so that people can play, have a custom workflow and then you can have more out of the box ones.
I have to say I've spoken to firms that are embracing vibe coding, and there's a lot to be said for it because you have that, it's like all that challenge of how do you get that intelligence from the expert's head, right? And you take
Absolutely.
away the need for a translator, which has always been the issue, right?
Yes.
Like how do you get the expertise?
I've wrote about this over the last few weeks. I think I've worked with lawyers for 20 years and I've been part of, I always think I had a good idea of what they were asking for in translating it to the engineers, but a lot of people don't have that ability and haven't been in the industry long enough. And they are probably better placed to vibe code the user experience better than the 5 layers of business analyst and project manager and senior engineer to junior engineer to actually get something built. So I think I'm very bullish on vibe coding. I'm super interested in this legal quant movement, and as I said, I really want to make sure we can try and support it because Again, it also feeds into the cost. If you can do it much more cheaply, then, I don't know, let's say we charge £50 per user per month. If somebody runs the math and can vibe code a Jylo for £20 per user per month, and there's a little bit of maintenance but not much, and the kind of math works out, then those are the types of things that are going to be going to law firm boards over the next few years with these legal quants that are sort of coming up everywhere. And we need to be competitive to that, which I think is fascinating, because on that side you've got that, and on the other side you've got really expensive products in the market.
Yeah.
Who
That's
perhaps
probably
don't.
what I was thinking about more, that's what I mean by the practice, not the little, yeah. A law firm, so there's a lot of, I'm seeing so much change, in terms of, and it's nice to see the excitement. I'm not a pessimist about some of this stuff. It's nice to see some of the excitement and energy around legal tech and tech. But it's interesting, the dynamics are kind of changing. So I speak to a lot of in-house teams now more than ever before, and they're kind of talking about taking more work in-house. And I don't know. I mean, I see the logic. They're kind of investing more in tech, but I'm not sure. I don't know. I mean, I do think long term there's some risks. What's your take on the sort of the changing dynamic there?
Yeah, I mean, I think as a CEO, if I had a general counsel and they were getting an external law firm to do work, and I could get something done far cheaper, depending on, I don't really care about the supply chain at that level, I just care about the value of the work and the cost, then things might get disrupted a little bit. But I'm not necessarily sure whether it empowers in-house or it empowers private practice or it empowers the CEO. And I think you could make arguments for all three. Data for the law firm, closeness to the business and in-house, and then cost and value for the CEO. But yeah, the supply chain is very interesting. I think a lot about that all the time. The supply chain of Thomson Reuters and Lexis, up to private practice, up to in-house, and up to the actual person in the law firm who wants to buy the service. And everyone's trying to win at every layer. Everyone's trying to climb up the value chain as well. You are hearing about certain legal AI companies that are now looking to do services. That cuts private practice out and goes straight to in-house. The Claude Legal plugin, people miss this. The Claude Legal plugin, if you look at the documentation, it says it was targeted to corporate counsel. It wasn't meant for legal. So maybe that's why law firms were a bit worried about it. But you look at that whole stack, and it's a bit confusing as to how it plays out. So, but as always, like, law firms are dead, and then unnamed massive law firm goes and posts the largest revenue number in the history of any law firm that's into the tens of billions. Sorry. So it doesn't look like the private practice industry is doing too bad. Certainly going down. Yeah.
That legal plugin was the Anthropic legal plugin. I've definitely, the people that were excited about it were heads of legal operations at in-house teams. I think that so. And I think that you talk about costs. I think that comes down to cost of software. A lot of the time, they don't have the budget. They're looking for options. And some in-house teams do have quite high technical resource. Some of them, I speak to, they're doing some really super cool stuff, and they're thinking about how they can play around with it. That's always going to be the case. I do slightly, in terms of in-house teams, thinking that they're going to bring in more legal work, in terms of that balance. I feel like they, I get that. I've written about the in-house market for years, and it goes like this, right? Depending 2008, suddenly the in-house market went up in terms of its power, and law firms went down, and we've had different periods of time when this has happened. This is not the first time. But I do think that speaking to somebody the other day, who's working for a law firm, so she's probably a bit biased, but she was saying, you've got to think about that expertise that law firms have to offer in terms of they're specialists. They've also got insurance.
Yes, yeah.
There's lots of factors at play, right? I think it's great though that I do think the enthusiasm is interesting. It's not necessarily a bad thing, and it's not necessarily a bad thing to keep anybody on their toes. I feel like perhaps in terms of the costs, law firms sometimes need to be kept on their toes. I don't know if you disagree.
Yeah, no, I think you're right. I think there's cycles, and it's going to be interesting to see how it all plays out. A really informed in-house team with a big budget could potentially start to do certain tasks that they maybe outsourced. The thing you always go back to is like NDAs, but then interestingly, like private practice usually do those anyway. And write them off because it leads to bigger work, or they've got some retainer that means that they'll do stuff for free. So there's always that draw and that competition between the two. So yeah, I think it just depends on the law firm. It depends on how forward thinking they might be versus not, versus how forward thinking the in-house team is going to be. But I think the other thing to be a little bit concerned about is some of the vendors who are trying to intermediate the relationship between the two. And I think that might be something that people need to just be a bit cautious of because of the data that's flowing back and forth. The other thing I always think about is, do in-house teams care if all of the IP that the law firm gives them that licenses it to them, and maybe this is a breach or not, I don't know, and they put that into a leading frontier lab, and that leading frontier lab improves its quality such that it brings the cost down. In-house probably don't necessarily care about that because they are a cost base, they're a fee burner, private practice fee earning, in-house is fee burning for the company. And so you do have that thing, that trend, which I think is quite interesting, which I don't think, I think in-house would be more aligned to going to like a frontier lab, and then maybe private practice going to like a GenAI wrapper like us and the others. And I think it's whoever, what I think law firms should do is very quickly get a platform they can white label and give back to in-house and brand it as themselves and help them so that they take that conversation off the table.
Yeah.
And the build versus buy conversation is kind of happening at the in-house team versus legal engineering. Do they build legal engineering or do they buy it? Right? It's talk about software engineering, but it goes right up to in-house. But I think if that doesn't happen, then the in-house teams will increasingly look to build. I think that's it, right? Build versus buy. Software, legal engineering. It's the legal engineering layer between the law firm, private practice, and the in-house team. And they'll be deciding whether they should build legal engineering or buy legal engineering. And that's that transition of IP. And they'll be making the same argument that private practice are making about the software element. Is it core to your business or not?
I was speaking with Ilona Logvanova, who's just joined Herbert Smith 3 years Kramer, and she was saying that it's up to the law firms to take the innovation to the client. Right now there's a little bit of trying to get the client to come up with a solution, and the clients are, and it's not necessarily always in the law firm's favor, but it's up to the law firms to go to the clients with solutions and go, right, here is what we have to offer, here is how we can use the tech, we've got this broader platform, we can solve your problems. But I think there's been, I don't know if you'd agree, feels like there's been a bit of a perhaps delay, or perhaps too much of the emphasis is on the client also solving the problem for themselves.
Yeah, I mean, I think what I would say, I think the models are getting to a place now where what we are seeing is senior lawyers are sort of sitting up and going, oh no, that was a really interesting output that added lots of value. That is the type of intelligence of a senior associate or senior counsel level. So lawyers are cynics by nature, but the more they start to trust the models and the more they start to, I do think they'll start to lean on them and depend on them. And then I think they'll start looking for ways to market that and productize that back to their clients. I think they'll navigate that carefully, but I do think we'll start to see a change. Certainly, I know I would say this, but all of our clients are now looking at ways to offer different services, certainly around the volume area where you're doing sort of big reviews and stuff, starting to find ways to say, well, actually, we could do that with Jylo. It would be a little bit different. We could do an early case assessment, first pass. And then if you think there's something here, then we could go into more detail and you could start to get, fees, hourly fees on with people looking at stuff, and the cost goes up, and then we start to trigger it insurance, whereas maybe we don't. And that's what we've always talked about, for the last 2 decades. But I certainly feel that we're starting to get there now.
So if you're listening, for everyone listening in, if you've got any questions as we sort of enter our last 10 minutes, let me know. Be keen to get your thoughts. There's been everything's gone a bit topsy-turvy in the markets as well. So you mentioned Anthropic, that caused the markets to crash, legal software markets to crash. Were you surprised about that? I feel like, it's like, so we talk about moat, and we talk about the big publishing companies and how they've got this sort of moat that can't be eroded because they've got so much data, but it doesn't seem to be that way in the markets right now. Was that a surprise to you?
I definitely think the large publishing companies have got a huge moat around legislation, regulation, and case law. I think that precedents, certainly with what you're seeing with Opus 4.6, they are increasingly being able to be generated by the model from scratch at a much lower cost, and they seem to be pretty good, because probably what happened was the publishing company's precedents went to the law firm. The law firm sent that to the in-house team. The in-house team hadn't bought a secure private AI tool. They popped it into a consumer AI tool that then fed its way back down to Anthropic, and then everybody got access to it. So if you look at the legal, certainly the public ones, you look at they got a stock price boost 3 years ago because everybody thought data was going to be really important. And I think it's just reset a little bit because people are going, actually, they've got a moat, but I think they're finding it really hard to protect it. As a buyer, you used to always have a term with the legal publishers that said this data cannot be put into any other system, certainly the AI systems. So they're aware of it, and they're obviously trying to protect it. I think maybe Opus 4.6, just these public analysts looked at the model quality and said, actually, this can generate pretty high quality legal data. That moat perhaps is being eroded slightly. We're going to reprice. So it was a big shock, but if you look back to 2002, to 2022, 2021, it's sort of go back. It's going back to those levels for some of them. But I think long term, if I could genuinely, like, this is not investing advice whatsoever, but that day that we talked, when it was SaaS Apocalypse was hitting legal tech with Claude that came out. Yeah. If I could have bought, I would have definitely bought, because I do think it will trend back up quite healthily. There's just a huge amount of data there that's not accessible to other organisations.
And because the nature of legal, as a a former lawyer, like you've got to get it right. There's not a bit right. That this is the thing. I mean, maybe sometime in the future, but certainly for any time soon, I can't see that be devalued completely.
The models are not allowed to regurgitate verbatim. That's a breach of copyright. So they're screwed on regulation, legislation, and case law, because the laws have to tweak it, and you can't tweak those things. So that's why they've got a moat. But on contracts and on precedents, you can change a couple of words. Nobody would ever know. Effective termination, a couple of different words, a share price value, a square bracket somewhere, and it would be different to the original training data. And then the model provider would get away from it because it's not a verbatim reproduction. Therefore, it doesn't trigger the copyright breaches. New York Times OpenAI got sued by New York Times because they could reproduce a verbatim article, and then OpenAI said, "Oh, we'll fix that," which is never do that. So legislation, regulation, and case law, even if the models get it, it just will never be regarded. It should never be trusted, and that's why the legal publishers are solid. But on the other side of that business, which is precedents, there's a huge part of that business as well. I think that's maybe where it starts to get eroded slightly.
Tell me, so what should be the key takeaways? I mean, if you were to say, like, that it's a period of huge uncertainty for everybody, there's some excitement, and I think I hosted a breakfast the other day, and it got quite heated actually as to whether it was like the end of lawyers. It was kind of funny, like, but actually genuinely quite heated. It was great, but they were saying one of the participants was saying, this is a huge opportunity in terms of using AI to really rethink your business model, and I think it's important to acknowledge that there's sort of challenges, there's opportunities for the people that really understand and think about this. And I think that's really what we're saying, isn't it? I think we're really saying here, really, let's think about, I mean, it is more existential than that, but really, have you thought about what it is that you're doing? Is there a strategy? What would be your key takeaways for people, if I was to put you on the spot for sort of a few takeaways?
I think the world is always moving. The new problems, new issues will come up, new legislation, case law, regulation, new precedents, new problems, new data. We would never call ourselves this, but I did think about, like, the AI for incumbents, so the AI white collar incumbents, professional services incumbents, or private practice, but like, I think law firms should try and find partners where they have absolutely no interest in eating their lunch. The law firm finds a way to kind of productize data on top of the platform, and then they find a way to either white label or give access to that platform to the client, and they take the client on a journey through this sort of transition into sort of modern AI world, and that allows them to continue to remain relevant and everything. And I think that's going to have to be the only trend, and I think that's a really positive trend for law firms, I think it's a really positive trend for in-house teams, because they might get some services a bit cheaper, they might get more things than they could have got before with their budget, and they'll be happy and the CEOs will be happy. So I think that's the really positive message. I think the counter to that would be very careful about, you know, who you're partnering with, and whether you have got these indirect ways for data to get out to the thing is, like, these frontier labs, they're so competitive with each other, and they're always trying to one up each other, so they are going to try and find ways to get that data. So just being really careful on that. And I think it's a really exciting time. I've been in the industry for 20 years. I remember when ChatGPT came out, I did a roundtable with FTI, with Rena and Yasmin.
Yeah.
And I was sitting at the table, I was like, this is revolutionary. Like, I couldn't shut up. And I think there was a lot of people kind of like, not really sure it's going to chatbot. And I was like, no, we've done verification with it, we've done e-discovery with it, we've done diligence with it really quickly and early, and we were like, this is amazing. And so I think it's a huge, I've in the industry 20 years, really excited about what comes over the next 20. It isn't all doom and gloom, it's not all automation. I think firms will find a way to navigate this and to build some digital representation of their firm on top of these frontier models. And I think that's going to be super exciting.
Yeah. Do you want to, I mean, we can deal with this in the post webinar. There is a comment about whether productizing is already happening, whether legal expertise embedded to prompts as an example. But it's a big time investment. I mean, we can deal with that afterwards, or we can just have a quick comment on that now if you'd like to.
What? Sorry, I didn't really get the question again.
Oh, sorry. So there's a comment. Sorry, it's me just like.
Sorry, I can't see it, but yeah.
That's okay. So I thought. I mean, what I really like about my conversations with you. This is slightly more challenging, perhaps, but what I really like about my conversations with you, you're always up for a challenging observation. So, there's. I think productizing is already happening. Legal expertise embedded into prompts to help clients with due diligence is an example. But they're saying that it's a big time investment that needs dedicated resources. It's not so much a question as an observation. I wondered if you wanted to just quickly jump in on that.
I totally agree. I think that's happening, and I think that's really exciting for the firms that have got there early and got there quick. And I do think that there's a big investment needed, but then, you know, there's a big opportunity as well that would come from that. And as I said earlier, just, you know, it's really, there's only a certain amount of capital that a law firm can deploy to this stuff, and they have to deploy it with absolute precision, in my opinion, which is probably going to be as lower prices you can get on the technology, and putting that downward pressure on that, and then finding a way to build a function that engages with the lawyers, not software engineers, but legal engineers. I think the legal engineers being reborn again and again and again, but maybe let's say legal quants, because that's more interesting. And building that kind of capability on top, yeah, I think that's probably the biggest opportunity. And yeah, I totally agree it's happening. I'm not suggesting that that's what's got to happen. There will be firms that are doing that. There'll be other firms where they don't need to do that. Do you know what I mean? There'll be real boutiques where it's really high-end work and it's closing a deal in person with a big company, and then they don't need to do diligence or something. There's some reason they don't. So there's going to be different models to it. But certainly for the larger firms, I do think it's an imperative.
Yeah. Unfortunately, we're at time. I think it's so thought provoking. I think it's really important. These conversations are super important. And I'm really grateful to you for initiating it. Actually, I'm grateful for people to listen. Grateful to people for listening in. I feel like this is the time. Like, it's very easy to get swept up and then ask questions later. And then go, how did that happen? So I feel like this has been super useful. Thank you so much to everyone for listening in, and thank you, Shawn, for sharing your thoughts as always. It's really great to chat.
Thanks, Caroline.
Thanks, everyone.